And Your Honor, Mr. Phoenix is one of the victims of the assault. It is my understanding that Colin Gray is seeking bond to be released from custody until his trial date. This statement is to express my vehement opposition to Mr. Gray's request. Appalachee High School, the city of Winder, Bexar County, and the surrounding communities are in the middle of a healing process due to the events of September 4th. September 4th was filled with hurt, hatred, and darkness caused by a 14-year-old student whose actions were driven by the decisions, choices, and actions of his father, Colin Gray. As a result of these choices and actions, the amount of pain that was inflicted on the school and the surrounding communities was unmeasurable. Lives were lost, people were hurt both physically and mentally, spouses were widowed, parents lost their children, and children lost their parents. There's a great degree of everlasting pain and hurt that will never go away and always be felt by students, parents, and members of the community. For me personally, I was shot twice, once in the hip and once in the foot. I spent 8+ days in the intensive care unit at Piedmont Athens Hospital. I've had 2 surgeries that involved rebuilding my hip, as well as multiple follow-up appointments to the orthopedic surgeons, physical therapists, personal counselors, as well as other medical doctors. While my diagnosis is good and there will be lasting effects from these injuries that will impact and affect me throughout the rest of my life. Our school and community are slowly healing from an immeasurable amount of pain. We have come a long way from 5+ months ago. Releasing Mr. Gray on bond would essentially rip off the bandage of that healing and create the very anxiety, hurt, and pain that we are trying to heal from. Mr. Gray does not deserve bond based on the inexplainable decisions and choices that prompted the deadly actions of his son on September 4th. Conversely, our school and surrounding community deserve peace of mind and comfort knowing Colin Gray is behind bars. It is for these reasons that I'm asking you to deny the bond of Colin Gray. David Phoenix.
That's all we have to say. Argument?
It's okay if I just stand here, too?
Yes, sir.
Of course, the event that took place September 4th of last year certainly devastated the community. Many of the people who testified lost people and injured.
Mr. Brady, let me get you to at least pull that microphone towards you.
If I can scoot around like
You can, or you can go to the podium where there's a microphone. Sorry to interrupt.
No problem, Judge. And we certainly see from the witnesses that testified and all of the things that we've seen in the newspaper, it's evoked a lot of emotion with everybody in this community. This is an unusual case. There have not been any cases of this type tried, only one that I know of in the United States where a parent has been charged with the crimes of their child. I would like to point out, of course, as the judge knows, Mr. Gray is innocent until he goes to trial. He's found guilty by a jury of his peers with competent evidence. That's not taken place yet. The purpose of a pretrial bond is not to punish him before his conviction. And that's why we have set out certain standards. The ABA back in 1968 set up standards. The courts here in this state adopted those standards. The cases that came shortly thereafter, Lane versus the state at 247 Georgia, 387, Burge versus the state at 238, 88, Ayala versus the state at 262, 704. All of these cases set out a criteria. The criteria is 4 different areas. One, that a person poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. The state has the burden of proving each of these 4 areas would be in violation. They have not done that. There's been no evidence that's been presented as to the first area, which is the fleeing the jurisdiction. He has been in Georgia all his life. He's lived in and around this area. The state pointed out that he had moved a number of times. However, all of the moves are within a fairly short area. The second, poses no significant threat or danger to any person, to the community, or any property of the community. The state has not shown that he would pose any significant danger. He had a misdemeanor marijuana charge 26 years ago. That's the only thing that the state has been able to show the court from that standpoint. Number 3, poses no significant risk of committing any felonies while out on bond. The state has not shown that he would be subject to committing any felonies. He's, I think, 54 years old. This is the first time that he's been in any trouble other than the 1999 marijuana. Poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state has not brought any witnesses before this court to show that he would be any significant risk of intimidating any witnesses. He's been in custody for all this time, has not caused any problems while there. In custody, has not attempted to contact any witnesses or intimidate any witnesses while he's been there, nor is any of his family. For those reasons, Judge, he certainly is eligible for bond. We feel that the court should grant him a reasonable bond under the Iowa guidelines and ask the court to give him a reasonable bond for that reason. Thank you.
Mr. Smith?
Your Honor, under 1761, a court shall be authorized to release a person on bail. Not that you have to, but you're authorized to release a person on bail if the court finds all of these factors. First one being that the defendant poses no significant risk of fleeing. Your Honor, I think the evidence today has shown that he has no ties to this community. The closest he can come to were some sisters and daughters that live in the metro area, is the best we've heard. He has a history before the crime. He had an incredible history of moving. He had 7 different residences in 5 years. Hall County, Forsyth County, Ben Hill County, which is almost in Florida, Jackson County. He's moved all of these places. 6 of these residences were rental residences. He also shows a significant risk of fleeing, Your Honor, in his candor to the court. Your bond would be an order of the court to come back to court. And even in his own testimony, he was asked, "Have you ever been arrested?" And he said, "No." Not even a misdemeanor? No. And then we pointed out twice he had, which it's not going towards his risk to reoffend, Your Honor, but it goes towards his lack of candor to the court. And it also goes to his no ties to the community. That was in Cobb County, Paulding County. He's all over the state, Your Honor. The next factor, no significant threat to the community. Your Honor, this was an attack on the community. This wasn't a domestic violence where you're attacking a specific person or a robbery where you're going after a specific thing. This was an attack on the community, which makes him a serious risk. There were 25 total charged victims in this case. The next factor, no significant risk to intimidating witnesses. Your Honor, the state is going to need to prove what happened in his household leading up to this shooting. And the witnesses are going to be his wife, his 3 children. Those are our main witnesses in this case. And they're his. And so there's a significant risk of him intimidating or influencing these witnesses. Your Honor, we would ask that you not grant a bail in this case for those reasons. The court, if you do decide to set a bail under Jones versus Grimes, a 219 Georgia 585 case, you can consider when setting a bail and the amount, the seriousness of the offense, and the penalty of those offenses. So if the court were to grant a bond, and again, we're asking that you not, but if you were, he's charged with murder in the 2nd degree, 2 counts. We would ask for the bond to be $100,000 per count, for a total of $200,000. He's charged with involuntary manslaughter, 2 counts. We would ask that the bond be set at $75,000 per count for a total of $150,000. He's charged with cruelty to children in the 2nd degree, 20 counts. We would ask the bond be set in the amount of $50,000 per count for a total bond of $1 million. And he's charged with reckless conduct, 5 counts. We would ask that the bond be set at $1,000 for a total of $5,000. So if the court were to grant bond, we would ask for an amount of $1,355,000 bond, which would be appropriate for the seriousness of these offenses. We would ask that you have no contact whatsoever with any of the witnesses in this case.
Any last word, Mr. Gray?
No, Your Honor, I think we've set out the criteria for setting a bond. We don't believe the state has proven any of the 4 elements that should keep him from getting a bond.
I'm going to take about, I'll call it a 10-minute recess. Hopefully that's sufficient time. But we'll be in recess for 10 minutes or until I return.